And we have a couple of our members on the computer.
Good morning.
Just speak loud enough they can hear you and make yourself comfortable. And when you're ready, give us a couple-minute overview on who you are and why you'd like to be a county judge.
Well, good morning, and thank you, everyone, for the opportunity to meet with you and talk about my application and my qualifications. I began my career as a prosecutor in Duval County, and I spent 5 years there. Judge Maltz was actually my first division chief. And then I went to work for my father, alongside him representing the Department of Revenue in child support enforcement, and then I became a child welfare attorney for the Department of Children and Families here in St. Augustine. And it was Judges Alexander and Judge Wolf that encouraged me to apply for the position when they became available of a magistrate and hearing officer, and I was subsequently hired by Judge Parsons. And I currently serve as the general magistrate for St. Johns County. When our children were little, they used to ask me, what is it you do at your job? And I would tell them that I meet with families who are not getting along, and my role was to make decisions for them so that they could better take care of their children and move on with their lives. You all are meeting with a laundry list of very qualified individuals today, and I'm honored to be among those. I do think that what sets me apart is my quasi-judicial experience for the last 14 years. As I'm sure Ms. Matthews can attest, I spend my days presiding over evidentiary hearings. I make difficult decisions. I manage large dockets. I then prepare written reports with very detailed findings and applying the law to those findings. So becoming a county court judge for me is an opportunity to take the skills and my experience and continue to work for St. Johns County. I love my job. I just want to do more of it for St. Johns County. And I know this is a long day for all of you all, so I am more than happy, out of respect for your time, to keep my remarks relatively brief and move on to your questions if you would like.
Talk to us about why a county spot instead of a circuit spot.
St. Johns County is our home. This is where our children go to public schools. We have one that has gone all the way through and graduated into their middle school. This is our community. I think that my skill set, both in criminal as well as family law and civil practice, make me a good candidate for a county spot. I've got both of those going for me. And I will be honest with you, simultaneously with deciding to apply was the thought of, okay, are you ready to run? If, given the history of what's been going on, are you ready to defend the seat if you were to get the appointment? And that went into my thought process, and the answer is yes. I think I'm qualified, and I think I'm ready to run a countywide election if need be. So.
Elaborate on that. How would you, what's your experience with running campaigns, and how would you defend the spot?
Sure. Well, thank you for the question. Like I said, I began thinking about it simultaneously with preparing my application. And that means going ahead and getting the information and making a plan for how do you select a campaign manager, and what level of funding am I going to need, and am I prepared to raise that or put it up out of our own pocket. That also, my plan, if I get the appointment, is not to wait a year and a half and see if somebody runs against me, but essentially start running a campaign from the get-go out of the seat. Making those mental lists that I've already got going about what networking I would like to do in the community, how to get my name out there, what groups I want to go, and just introduce people to the new county court judge if I was so fortunate to get that appointment. I am very involved with our temple. I've had some leadership positions with that for the last 10 years, serving on the Board of Trustees, as well as vice president, acting vice president, and then a term as president. So in addition to that, obviously I participate in the local bar association events when I'm able to. I'm an active member of the St. Augustine Inns of Court, and I think the bottom line is, for me, it comes down to timing. And my husband, while he had a great career in social services, is now a small business owner. He's got a little more flexibility, but he's also out in the community even more. And our children are older. I think they're in a better position to support me if I need to run a campaign than they were 10 years ago. And I actually find myself looking forward to it.
Talk to us about your jury trial experience.
Well, first 5 years of my career were as a prosecutor. So that was in Duval County. So I began, as everybody did then, as a county court prosecutor. Handled a number of DUIs, domestic batteries, misdemeanor batteries. Then I moved on to felony court and handled some aggravated assaults and various jury trials. So I mean, it's been about 20 years, because I will admit that I've been practicing for 25 years now, but I do have that experience. I'm comfortable with it. I approach a jury trial the same way I approach every proceeding. I apologize, you'll see my notes here. I've never walked into a courtroom without notes and without being prepared. It's just part of what I do. No matter how many trials I had, I still would, on the left-hand side of my legal pad, write the elements of the offense so I could check them off one by one after you demonstrated them. So, and then of course what I do involves the same rules of evidence, the same rules of procedure, civil procedure, are not that far different. So I think my experience is solid.
As a general magistrate, I assume not everyone that comes before you is represented, similar to county court. And so how do you handle that right now with what you do?
Thank you. I would venture to say probably a conservative estimate is about 75% of the people that come in front of me are representing themselves, pro se litigants. And one thing I do for everybody that walks in is I introduce myself. I begin the hearing by telling them, I'm Denise Mensh, I'm the general magistrate, our proceeding is being recorded. I think they're entitled to know what's going on. And when I have pro se litigants, whether there's an attorney on one side or both sides are pro se, I would typically then go over with them what the motions or the pleading or the petition is that we're hearing today. And then I give them all roughly the same speech of, I recognize that you're representing yourself, but the rules of evidence, the rules of procedure still apply. I'm not able to give you legal advice. I'm not able to tell you how to present your case. And then I go on to explain to them if it's the petitioner's motion, then I will say that Ms. So-and-so will have an opportunity to call her witnesses and present her evidence and testimony first. And then you will be entitled to ask questions, and then you'll have an equal opportunity. So I think my tactic of approaching the pro se litigant is to try and give them as much information so they know what to expect from the hearing. But again, at the end of the day, I'm not there to advocate for them. So I try and give them all the tools that they will need. But at the end of the day, then I will treat the case evidentiary-wise the same way as any other case.
Can you hear me? I'm on Zoom.
Good morning, Mr. Morgan.
Good morning. On your application and your references, you had several local attorneys who I'm very familiar with. And I will say that that everyone, the family law bar speaks very highly of you. How do you manage keeping the lawyers happy when you're ruling against them? I mean, that to me is the skill.
Well, I guess you can tell me if I've kept you happy, Mr. Morgan. I think what I try very hard and what I'm very committed to doing is to treating each case individually. There's no biases. Every case is coming in front of you, and you look at the evidence, and the evidence that's presented not necessarily all the evidence that could be. You look at the evidence that's presented and apply the law to the facts that are presented, and I think at the end of the day, as long as people feel that they were given their opportunity to be heard, that they were treated with respect, that the courtroom, as much as it can be, is a pleasant experience. And I think that my rulings are consistently demonstrate that I apply the law to the facts. And I think most attorneys will acknowledge that you can't always have the winning side, and that if everybody was going to be happy, they're probably not going to come into a contested hearing. So I think hopefully that's what the attorneys that come in front of me take away from it, is that they're treated fairly, their client is treated fairly, and they're given an opportunity to present their case. And I consistently treat everybody with respect.
Can I ask another question? First of all, I've never had the losing sides. I asked the previous applicant this. You know, if you're a county court judge, you're going to be in a situation where a public defender or a private attorney is asking for, let's say, probation, and you have a prosecutor saying, you know, this person should go to jail. What are the things that you would look to in deciding, you know, how to sentence somebody? What is important to you?
Importance, number one, first and foremost, I think you look, is there a victim of the crime? And does the victim have an opportunity to provide some input as to their recommendation? I will liken that to dealing with child support contempt hearings, and while a lot of times I may be looking at the record and ready to recommend an immediate purge and possibly jail time, I may have not the custodial parent who's entitled to the support saying, whoa, I don't want them to go to jail. You know, I just want to get through to them. So I think the victim's voice is entitled to be heard. I think you certainly look at the past record. And you also, I think there should be consistency in a courtroom. I don't plan, if I'm given the appointment, of assuming I know everything and I can just, you know, sit up there with the gavel and start going. I mean, the first stop is to talk with Judge Christini and Judge Tinlin and get their guidance, get their experience, get the benefit of that. And, you know, what is common in this locale for this type of an offense. And at the end of the day, I think it's about what's appropriate. I mean, I began as a prosecutor, so I would be mindful of not going in with a certain bias and making sure that both sides were given an opportunity to make their arguments. I hear that. I know it's not the criminal offense, and what I do is family law, but I don't know how many hundreds of cases I have two parents sitting there each saying, give me majority time sharing, give me majority time sharing. So you have those competing interests. And what you have to do is go to the law and apply the law to the facts. And I think 99% of the time, when you go back and you look at the law itself, it's going to guide you to the right answer for that particular situation.
Ms. Mensh, this is Chris Green. Good morning.
Good morning.
I'd like to hear a little bit more about your interaction with pro se litigants. You, of course, see a lot of those in county courts. Just like to hear your thoughts on what is the role of a judge dealing with pro se litigants.
Thank you. The role of the judge is to make sure that a pro se litigant, just like a represented litigant, is treated fairly, is given due process, and is given their opportunity to be heard. I think it's important to not advocate for a pro se litigant, but to prepare them for what to expect during the proceeding to the best I can, as I went over before. I don't think that, aside from a county court judge, that there's anyone really other than a general magistrate who really has as much experience dealing with pro se litigants. And I think that at the end of the day, the same law is going to apply whether somebody has an attorney or not. It's just doing what you can to be respectful, probably a little more patient sometimes, and treat everybody fairly. And I think as long as you do that, then somebody can walk out of the courtroom saying, maybe I didn't get what I want, but at least I got a chance to be heard. And I feel like the judge or the general magistrate listened to me. And I think then you've done your job.
Ms. Mensh, good morning. It's
Good
Raven
morning.
Stewart. So you are probably the only one of us who's gotten a different perspective using Zoom, having to conduct hearings. And so my question to you is, going forward, if you were selected to become a county court bench, would you continue to utilize Zoom to the point, obviously that the chief judge allows it?
I think Zoom has been a wonderful tool, and you're correct, just for those of you who don't know, the administrative order has required that everything as a magistrate I do is by Zoom. The only exception is if I have a sign language interpreter. So since June of last year, I have conducted every single hearing every week by Zoom. And I will tell you that one of the things that is remarkable to me, Ms. Sword, is that I actually think the attendance of the pro se litigants has been better via Zoom. I find that they don't have to take a whole day or even a half day off from work. They can appear using a smartphone, and the attendance is not bad. Not gonna lie, every once in a while I have to explain to somebody that clothing is mandatory for a court proceeding, and would you like an opportunity to go put a shirt on? I'm very comfortable with the technology of it. I have a wonderful assistant who's done a great job training me on it. So I'm very comfortable with it. I think that going forward, I think there's always going to be a place in the judiciary for the use of it, for the convenience of the attorneys, for the convenience of the litigants. Certainly there are some aspects that are better off being heard in person. So to answer your question, I believe that I would be more than prepared to go forward using it to the extent that there was a balance between the in-person hearings and obviously trials and things that need to be, and using Zoom. And obviously, as I'm watching myself on the screens around here, our courtrooms are really set up for it now. It's working very well. And I think it's a tool just like anything else that should and could continue to be useful to the court.
Thank you.
I have a question. I learned really quickly when I became a magistrate that it takes courage to sit in judgment. And I know you've learned that lesson as well. Can you tell me your experience about how sometimes rendering opinions or rulings has taken real courage on your part?
Absolutely. Excuse me, my father was kind of always my biggest mentor, and unfortunately I lost him in January of this year. But he told me when I took the position, basically, you're not there advocating, you're calling balls and strikes. So you're looking at the facts and you're applying the law to it. Family law is its own unique animal. You can't ignore the fact that you're changing people's lives sometimes with what your decision is. And a lot of times you're changing the life of somebody that doesn't get a say in it. It's the child. So what I have kind of found is that every once in a while there's that case that I've just, I know sometimes the attorneys think maybe I'm not doing my job as quickly as possible, but what I'm doing is I've got to live with that case. I've got to live with it in my head. I've got to take it home and kind of let it marinate and give it some thought and come at it the next day or the day after that and keep thinking about it and looking at it from as many angles as I can get, because it is such a weighty decision. I think that I appreciate you recognizing it. It does take courage, because there are certainly plenty of times where applying the law to the evidence that was presented may not be even what you think the outcome was going to be at the start of the hearing. And that may be because the evidence one side chose to present or didn't present, or because you have a pro se litigant that didn't know what to do. But at the end of the day, you still have to have the courage to follow the law, apply the law, and apply the law consistently to the facts. So it's incredibly important, and thank you for recognizing that.
Thank you.
Any other questions? Well, thank you very much, and the number that's on your application is the correct cell phone number?
Yes, sir.
Well, we'll finish the day and give you a call after that and let everybody know, who made the final list.
All right. Well, thank you all very much for your time. I appreciate it.
Thank you.
Thank you.